I recently wrote about how the Ohio State University is preventing white supremacist Richard Spencer from speaking on campus. Despite falling under the First Amendment, Ohio State is looking for a legal loophole to block speech it doesn't agree with. The semi-comforting news is Ohio State is subject to legal challenge. Not so in cyberspace, which Justice Anthony Kennedy called the vast democratic forums of the Internet in general, and social media in particular. There, access to diverse ideas is controlled by corporations and their terms of service. Hiding behind the bushes of private ownership, the quasi-public forums on Twitter, Facebook, Google, and their predecessors and successors, skirt the First Amendment to control what people say, read, and by extension, think. They are the censors the Founding Fathers feared. It is time to expand the First Amendment to quasi-public institutions. The scope of the First Amendment has regularly expanded. In the earliest days of the Republic, it applied only to the federal, and not any state, government. It wasn't until the post-Civil War incorporation doctrine, followed by court cases well into the 20th century, that those restraints applied equally to the states. In its own founding days, Ohio State could have easily banned a speaker. Actually, Ohio State might have been able to ban a speaker it found offensive until even more recently. It wasn't until a 1995 case that the Supreme Court held a university's choices on funding student publications fell under the First Amendment's obligation not to discriminate against particular viewpoints. Other expansions of the First Amendment took place in the 1950s, when the court,